Thank you for that introduction, Francesca. And I'd just like to quickly thank you, give a thanks to Francesca, to Mary, and to Adriani for inviting me to chair this extraordinarily interesting panel, which I've been looking forward to. I am the director of the Global Detention Project in Geneva, Switzerland. This panel, panel number 2 of the conference, is about the very important activity of human rights monitoring of immigration detention. And we are fortunate to have 6 very interesting speakers, all of whom represent different monitoring institutions nationally, regionally, and internationally. And as with the previous panel, each speaker has 15 minutes. We have 6 panelists. We have just over 2 hours. So I'm going to ask you to please do your best to stick to those 15 minutes so that we can have a Q&A afterwards. I will turn off my screen when each panelist begins, and at the 10-minute point, I'll come back on screen so that I can start to threaten you that you have only 5 minutes left. And then you'll know that you've got 5 minutes, and then we'll quickly go through the speaker, all the speakers before we get to questions. So without any further ado, we'll begin. We've got 6 speakers, as I mentioned. I'll mention them, their names. Hugh Chetwynd, who's the division chief at the European Committee for the Prevention of Torture. George Nikolopoulos, who is the deputy ombudsman at Greece's Ombudsman's Office. Elena Adamoli, who's the senior member of the Italian National Guarantor Office, which is the Italian NPM. João Costa, who is head of Portugal's National Preventive Mechanism as part of the Portuguese Ombudsman's Office. Carmen Comas-Mata, who is a member of the Spanish Ombudsman's Office and vice chair of the UN Subcommittee for the Prevention of Torture. And Hinpal Singh Bui, who is with the UK Inspectorate of Prisons, the HMIP. We're going to begin today's panel with a paper by Hugh Chetwynd. Hugh has been working at the Council of Europe for more than 25 years. From 1993 to 2002, he worked on criminal justice reform and local democracy issues, about abolition of the death penalty in Europe, and training of legal professionals on the European Convention on Human Rights. From 2002 to 2005, he headed the Council of Europe's office in Bosnia and Herzegovina. And from 2005 to the present, he has worked with the European Committee for the Prevention of Torture, the CPT, assessing the treatment of persons deprived of liberty in 47 countries. Although his division is responsible for countries in the Mediterranean, the Western Balkans, and the UK. He has worked on a number of thematic issues, including solitary confinement, life-sentenced prisoners, immigration detention, combating police impunity, and children in detention. His presentation today is titled The CPT, A Critical Voice for Minimum Immigration Detention Standards in Europe. Hugh, panel's yours.
Thank you very much. I wanted to share the screen, which worked beforehand. And here we go. There we go. So thank you. Do you have it? Yeah. So thank you very much. I'd like to begin by just thanking the organizers. I think this morning already was incredibly interesting and raised a whole series of questions from practical people like me who are working a little bit on the ground. This morning, I want to just look a little bit 4 issues: the role of the CPT very quickly, the minimum standards that have been set up for immigration detention, to provide a little examples from the ground, to touch on border monitoring, and then just to say whether or not I think it makes a difference. The role of the CPT, very quickly, we are there to try and prevent ill treatment through objective findings on the ground, fact-finding visits, and to provide adequate recommendations to governments to change the system in place. And our approach is to complement judicial with preventive, so we come before, hopefully, people have to start taking cases to court, and particularly the European Court of Human Rights. We work in 47 countries, as has already been announced. So it really does cover the whole European space. We have very wide powers in that we're able to visit any place at any time of the day or night where we think somebody's deprived of their liberty. And during those inspections, we have unlimited access to any place, to interview any person in private, whether it's a staff member or somebody who's detained, and to access all documents that we think are relevant to help us understand that place. We've been actively monitoring immigration detention places for over 25 years, notably in the Mediterranean area. And our focus in the last few years in particular has been on countries such as Greece, Malta, Italy, Cyprus, Turkey, Spain. But we've also been, especially after 2015, looking at the Western Balkans and the migratory routes, Bulgaria, Croatia, Bosnia-Herzegovina, Hungary, North Macedonia. And then we do, as well as part of our work, look into the situation in migration detention in other countries, such as Denmark, France, the UK, etc. As a starter, I'd like to say that the CPT would prefer not to have to see migrants being detained. And we very much encourage the use of alternatives to detention. And we try and promote also the 2019 Council of Europe guidelines on alternatives to immigration detention. Having said that, under Article 5 of the European Convention on Human Rights, immigration detention is permitted, provided that action is being taken by the authorities to either effect a deportation, a return, or prevent some unauthorized entry into the country. Nevertheless, deprivation of liberty of irregular migrants must neither be arbitrary nor the automatic consequence of an alleged violation of immigration legislation. This means that immigration detention should always be exceptional, proportional, and by consequence an individual measure which is necessary to prevent unlawful immigration. In line with the administrative nature, this means that immigration detention must not be punitive in character. It is not a sanction or a punishment. Therefore, immigration detainees should be afforded both the regime and material conditions appropriate to their legal situation. And the CPT's role has therefore been to ensure that where migrants are detained, they are provided with the minimum treatment and conditions. This means that there are a number of basic safeguards that should apply throughout. Detained persons should, from the very outset of their deprivation of liberty, enjoy basic rights such as access to a lawyer. They should be examined promptly by a doctor upon being admitted. They should be able to contact somebody, a third person or a relative, to tell them where they are. In this respect, they should have access to their mobile phones, which is often what contains most of their life in terms of what their possessions that they've been able to bring with them. And of course, they should be informed in a language that they understand about what is happening to them, so they can understand what are their rights and what are the procedures that are applicable to them. And this means, of course, in all these detention places, there needs to be access to interpretation. In addition, it is essential that all persons who are detained can have access to an effective legal remedy to have the lawfulness of their deprivation of liberty decided on speedily by a judicial body, and that they can have their detention reviewed periodically by an independent authority. As regards to detention conditions and regimes, we've made it very clear since the beginning that persons detained should be accommodated in centers specifically designed for that person, for that purpose, which offers material conditions and a regime that's appropriate. And these places should not be carceral. We've already heard, unfortunately, from Evgenia earlier today about the terrible situation in Greece. And the CPT has made it very clear that police stations and airport transit zones are totally unsuitable for holding persons in detention. They may be held there for very short periods, for 24 hours or less, for identity purposes, but then they are not appropriate. And there have been many judgments from the European Court of Human Rights making that clear. Likewise, prisons should not be used to hold immigration detainees. And again, we have repeatedly criticized different countries, notably Ireland in 2019, Germany, where we find persons who are migrants, asylum seekers, who are being held in prison. It seems self-evident that these places of detention should provide basic living conditions, and that within the detention facility, people should be able to move around as unrestricted as possible. And that the longer the period for which they are detained, the more developed should be the activities which are offered to them. It is also quite evident that the staff who are looking after these persons in these detention should be carefully selected and receive appropriate training. They need to possess interpersonal communication skills and cultural sensitivity, and if possible, they should be able to communicate with the persons in languages other than necessarily their own. And we should not see staff carrying things such as batons or handcuffs or pepper spray. And yet, all too often, in far too many countries, the approach is one of police officers and security guards with a security-only profile. It's also clear to us that if we are going to have persons in detention, that one of the key issues is that they must be provided with adequate health care. And this is so important given some of the traumatic journeys that most of these people have had to endure. And this is something that the CBT looks into very carefully each time in going in, is to see, to make sure that persons are properly medically screened upon arrival, which is in the interest of everyone, both in a view to identify those who are at risk of self-harming, screening for transmissible diseases, and timely recording of any injuries. And unfortunately, time and again, we've come across cases with persons who are suffering from skin infections or illnesses such as tuberculosis being held in totally unacceptable conditions and not being granted any kind of medical support. Likewise, persons who are detained need to have access to psychological assistance and psychiatric care where necessary. And again, all too often, this is not provided. And more generally, I'm afraid to say that the minimum standards and treatment that I just laid out are not respected. And worse still, far too many people are kept in caged conditions that would be considered totally unacceptable for holding animals. And this is a real problem, whereby I remember visiting back in 2011 with an interpreter, and he had just been working with the European Union. And he was totally outraged that he could be seeing people being held in such terrible conditions when he'd been working as an animal inspector just recently. And he was explaining to me how the European Union regulations for the keeping and transport of animals would never have permitted such a situation. And I think this is part of the problem of how we do not treat persons coming in as they should be as human beings. 10 years on, it is unfortunately, the Council of Europe has attempted to draft a recommendation on administrative detention to put forward basic minimum standards which should be documented in all cases and applied. And yet this simple soft law recommendation has been stalled because the European Commission does not want to see a provision stating children should not be detained. And this after the European Commission has tried to undermine some of the basic safeguards and minimum conditions which I referred to a little bit earlier. The European Commission and member states of the European Union still appear to think that harsh immigration detention conditions will act as a deterrent for persons coming to Europe. And yet we know more often than not, push factors are driving people towards Europe. And it is only the pull factors are not as big a play as we'd like to, as people think, even if a life in Europe may represent something of a pull. I just want to briefly mention a country that we visited recently and which has been at the forefront of migration problems. And this is Malta, which is for a few years, up until about 2011, again, it had a situation where immigration detention was very criticized, and then it didn't have too many people. And instead of taking the advantage to reform its system, prepare for when there would be more people, it did nothing. And last September, we visited Malta, and we found a system that was totally broken, where people were being held in very poor conditions. And it basically, we explained that it was institutional mass neglect. And the carceral design of the detention centers, such as the one you see here, are totally inappropriate, with large rooms crammed with bunk beds, no privacy, and communication via locked doors, and no activities, and little access to fresh air. Vulnerable migrants, in particular, didn't get any care and support they required. And not only were young children, their parents, as well as unaccompanied and separated minors being detained, but they're being held in terrible conditions with unrelated adult men, with no clear protection policies and protocols for looking after them. For the CPT, such living conditions and approach, made worse also by specific COVID-19 measures, was such as we could not refrain from calling them inhuman and degrading. What is perhaps positive in the light of this is that the Maltese authorities did actually acknowledge that this situation was totally unacceptable, and they have taken measures in the last 6 months to totally change the situation, to hire professionals instead of the private security firms, and to transfer people into open centers, and to ensure that people are provided with a better access to the asylum procedures as well. Time will tell whether this is a lasting success or not. I want to briefly touch upon Greece. I know there's a lot of persons already, and Evgenia has given a very moving and personal account of earlier today of the terrible situations of trying to work in Greece and in the immigration detentions. But it is unfortunately an ongoing country which is in a priority for us, and which has time and again, unfortunately, proven incapable of providing conditions that that are not in violation of Article 3 of the Convention. I would like to just say that in all the different times that we visited, what we've tended to find is that not only the appalling conditions in the different detention centers, and that when these have been found out, the authorities will always take small steps to try and improve the situation. But the fundamental premise of making immigration detention conditions tough has never gone away, and it remains at the core of the Greek approach towards immigration detention, and I would say pushed on by the European Union, which wants to hold people as far as possible as far away from the main parts of Europe, and therefore Greece has been given that role in many respects. There was a slight hope post-2011 that they would develop into a proper immigration detention system through the pre-departure centers, but instead they very quickly came to be dominated by a security approach and a warehousing for very long periods of up to 18 months. So Greece, I think, is still at the forefront and clearly under pressure from the European Union not to let people in and to minimize the rights for migrants, including, as we've heard already, detention of children. And these are some of the places, of course, that we've found in the past. I'd just like to touch upon border monitoring in a very few words. This will be looked at more when we talk about pushbacks, but it's something we started to look at more and more in the context of operations to forcibly remove people from the external borders of the European Union: Spain, Hungary, Croatia, Greece. The Commission has proposed that there should be an independent monitoring mechanism in each country, but we're not at all convinced so far that such mechanisms are effective and independent. Just recently, we laid out some criteria for how such monitoring mechanisms should be set up. There's no time now to talk about that, but I do want to note that it is absolutely important when we're going to be doing border monitoring that it is possible to operate on both sides of the border in order to obtain the necessary evidence and to prove that governments are pushing people back and pushing them back with incredible amounts of violence as well. So in conclusion, I just would like to say that I think that clearly in the political environment within Europe, there's a general approach to make life for migrants difficult. And in certain countries, that means making immigration conditions in detention very tough. The CPT and other national monitoring mechanisms represent a critical voice in ensuring that the treatment of migrants is fully documented and abusive practices are brought into the public domain. However, it appears evident this is not sufficient to guarantee the rights of migrants and to ensure their decent treatment. The reports produced by monitoring mechanisms do provide independent material which can help to sustain court cases, notably at the European Court of Human Rights, but also domestically. And they in themselves then bind governments to change. Perhaps on a slightly positive note, on having gone back to Greece, I met recently some senior police officer, and he did confide that the work being done by the CPT and others should be continued, and that we should continue to press the government and the European Union as it was having an impact, albeit very slowly. Going forward requires sustained pressure on governments to promote alternatives to detention wherever possible. And if detention is considered necessary, it must meet minimum standards. But above all, we must stop the detention of children in immigration detention. Thank you very much.
Thank you very much, Hugh, for that presentation. The CPT plays such an important role in what's going on in immigration detention across Europe. I look forward to some questions about the CPT later. Just to remind people and to encourage people to please put questions into the chat box so that we can start tracking them now. Our next presentation, speaking of Greece, is George Nikolopoulos, who's with the NPM in Greece. George is a professor of criminology at Pantheon University of Social and Political Sciences in Athens, and he has pursued a career as an attorney of law in the Athens Bar Association. He has studied at the Faculty of Law of the University of Athens, and he holds a PhD in criminology from the Faculty of Law and Criminology of the Catholic University of Louvain. He is currently Deputy Ombudsman for Human Rights at the Greek Ombudsman's Office and is responsible for overseeing the National Preventive Mechanism of Greece. He has been a member of the Greek Central Scientific Council for Prisons and is the past president of the Administrative Board of Epanodos, which is a Greek official center for reintegration of ex-offenders. George's presentation today is titled "The Greek Ombudsman as Human Rights Monitor and International Protection Procedures, Recent Developments in the Implementation of Administrative Detention Measures and Forced Returns Operations." The floor is yours, George.
Thank you, Chair. I express also my special thanks to the organizers for their kind invitation to address this conference. I would like to present to you briefly the multiple and diverse ways by which the Greek Ombudsman fulfills its role as human rights monitor in the international protection procedures according to the mandates granted by the state. At the same time, I shall make also reference to the most important issues actually raised in this field and constitute also the main subject investigated by our authority. In this regard, I might point out from the beginning that the extraordinary conditions generated by the coronavirus pandemic and the measures taken to confront it affected seriously not only all of our activities in their operational aspects, but also the content itself of the complaints received. As a matter of fact, we suspended the most of our on-site visits, and in many instances, we replaced them by alternatives and more innovative ways of intervention, without, however, failing to propose to the administration the relevant measures to be taken. Turning now to our competences, I should mention in the first place the Ombudsman general competence of mediating with public authorities, and in this regard, citizens' complaints offer us an important feedback for the developments in the field and the administrative procedures regarding the management of populations on the move. In this context, we take account of the overall process for access to legal protection for the refugee status from pre-registration, registration, and identification of persons that belong to vulnerable groups, up to the completion of the administrative asylum process. Also, we investigate the implementation of the arrangements regarding administrative detention, as well as the forced return and readmission procedure for those third country nationals whose asylum applications have not been upheld. Actually, in a considerable number of complaints our office investigated, the topics that figure most regularly appear to be related to the implications of political decisions, namely the closure of all the open accommodation facilities for asylum seekers in the Aegean Sea Islands and the creation of new closed reception and identification centers governed by more strict rules of controls. This development is more clearly visible in the island of Lesbos, from where, moreover, most complaints come to us, and raise the issue of the transfer of asylum seekers from the already well-functioning accommodation facilities at the municipal camp of Karatepe and the Pikpa to a new one provisionally set up after the Morias camp demolition last September in the place of Mavrovouni, in an abandoned firing range. All the applicants were vulnerable persons and protested that although in need of special guarantees, the material conditions in the new facility at Mavrovouni were not at all appropriate. In relation to this issue is the more general problem of assessing persons belonging to vulnerable groups by the reception and identification centers, as well as of providing them with special care and guarantees. Despite the fact that the existing laws include a provision on special care for this person, it is proven that its implementation is particularly difficult due to the significant shortcomings in the screening procedures in combination with the inadequacy of suitable facilities. A closely related issue we have also ascertained is significant omissions in the procedure for the identification and protection of persons victims of torture or persecuted due to their sexual orientation or gender identity. Although the transfer of particularly vulnerable individuals from the islands to the mainland is allowed only after their identification as such and the achievement of their registration process, we have been informed by the Regional Asylum Service in Lesbos that there is actually a great overloading of the relevant office due to the multitude of requests of vulnerable persons combined with the burden of the measures against COVID-19, which make scheduling the request even more difficult. Coming now to the special competencies of our authority, I shall mention two of them. The National Preventive Mechanism Against Torture and Ill Treatment under OPCAT, as well the external mechanism for monitoring the forced returns of third country nationals. As it concerns the National Preventive Mechanism, I must say that running now its 8th year of operation, it aims at establishing an integrated monitoring and inspection system focusing on the protection of human rights of individuals detained or deprived of their freedom on any grounds, criminal, administrative, psychiatric, or welfare. Regarding specifically the mechanism's main findings about the detention of third countries' citizens, it is worth pointing out our recurrent remarks to the administration on the inadequacy of living conditions in police cells for administrative detention in view of return. Overall, during its systematic visits and on-site inspections to the pre-removal detention centers, the Greek Ombudsman re-identified the main deficiencies in material, technical infrastructure, and staffing. The absence of medical and nursing staff, which makes even the receipt of necessary medication difficult, and the absence of interpreters, administrative employees for carrying out administrative procedures, remain fixed shortcomings. However, a positive development in this area is coming from the recent legislative reform about the detention of unaccompanied minors, providing the abolition of the so-called protective custody for them and their accommodation in adequate welfare structures. Actually, as I have already said, due to the extraordinary conditions generated by the coronavirus pandemic, the NPM's plan of on-site visits and investigations has been suspended and in many instances replaced by alternative ways of intervention, as for example, obtaining direct information from the relevant administrations, handling of complaints sent from detainees, having input by NGOs and media, etc. The Greek Ombudsman, in his capacity as NPM, addressed in the beginning of the pandemic on March 2020 a letter to the relevant ministries with a list of guidelines and specific recommendations for each category of detention facility in line with the SPT's advice relating to the coronavirus pandemic and the CPT's statement of principles with a view to informing on possible measures aiming at reducing the risk of an eventual coronavirus case spreading through both detainees and the staff. High among the set of our recommendations we addressed were, on the one hand, the decongestion of detention places by imposing alternative measures to detention for those detainees for whom it is legally sound and there are reasonable grounds to do so, and, on the other hand, the provision to ensure the same level of personal hygiene as is to be followed by the general population for all those who remain in detention and for the staff. Another one important special competence that involves the Greek Ombudsman in the protection of the rights of the population of the move is that of the national mechanism for the external monitoring of forced return procedures according to the relevant European Union Directive on returns of third country nationals to their countries of origin. The monitoring scope here is safeguarding the legality of the return procedures and the fundamental rights of the returnees and providing for the transparency of the operations by the Greek police. In this area, the challenges that are faced by Greece can be viewed only as a subset of the European-wide picture of the situation. In a European landscape, where the substantial disputes around the proper treatment of both asylum applicants and migrants are heating up, returns of irregular migrants are only a small piece of the whole European puzzle. With respect to its action as an external monitoring mechanism and with the experience of its experts' participation in joint European operations, in which Greece did not participate, the Ombudsman recorded serious weakness in the external auditing system at the European level, especially with regard to ensuring the auditor's transparency, accountability, and essential independence from the auditee. In particular, the Ombudsman considers that Frontex operation of a European Union pool of monitors, pursuant to the previous and the newer version of the European Border and Coast Guard regulation, essentially converts the external monitoring into an internal monitoring. The reason for this is that although the members of the European Union pool of monitors are proposed by the respective national mechanism, they still report to Frontex. Considering that the absence of essential external control constitutes a serious institutional deficit at the European level, the Ombudsman took the initiative to create an independent mechanism that will undertake this function in joint European forced return operation in a uniform and effective manner. This initiative was given the name NAFPLION initiative after the city in which the initial preparatory meetings were held between the European Union member states counterparts with the support of the Council of Europe. These meetings resulted in the creation at a special meeting in Rome on 2019 of a mechanism for the external monitoring of European return operations of third country nationals. The objective of the new independent mechanism is to protect fundamental rights and to ensure the transparency and legality operations and the accountability of involved parties. Actually, the main challenges ahead for fundamental rights in the context of immigrant returns are coming notably by the COVID-19 pandemic and the new pact on asylum and migration proposed by the European Union Commission. As far as pandemic is concerned, the Greek Ombudsman recommends adequate health precautions measures for detainees, returnees, for example, tests during detention and prior to return, as well as vaccination of the detainee population. Regarding the proposal for a new pact on asylum and migration, we are seriously concerned by its stipulations for pre-entry screening of asylum seekers and swift returns of irregular migrants at the borders. On the other hand, the pact proposes the independent monitoring of the border procedures, and in this regard, the Greek Ombudsman considers that it would be an essential safeguard for fundamental rights on the field. As I have only 2 minutes, I just like to mention that apart from the case of human rights, monitoring in the legal operations of forced return, the Greek Ombudsman expressed also an interest in the alleged pushbacks to Turkey of foreign nationals who had arrived in Greece seeking international protection and decided his own initiative investigation on this issue. Recently, we have published an interim report on pushbacks, and summing up, I should like to mention that you can find in our website the general and special reports that we publish annually on all these matters, and so you could provide you with a comprehensive account of the Ombudsman's findings and conclusion. As a concluding remark, I would like to mention that stable patterns in asylum migration policy as the long-term and arbitrary use of administrative detention, as well as the insouciance for human rights, are taking now new forms due to changes of circumstances as it is the current context of coronavirus pandemic. Thank you for your attention, and I make myself available for the discussion. I'm sorry for the time.
Thank you, George. Thank you for that, for updating us on the situation in Greece, which is so critical, as we all know. I'm sure there's going to be quite a few questions for you at the Q&A. Our next panelist is Elena Adamoli, who is with the NPM in Italy. Elena is a senior member of the Italian National Guarantor's Office, Italy's national preventive mechanism. Since 2016, she has monitored numerous places of detention, of deprivation of liberty, and drafted official reports about this work. In addition, Elena has worked as a forced return monitor assessing implementation of the European Union Directive 2008-115, better known as the EU Return Directive, which has involved monitoring national and Frontex chartered return flights. Over the last 5 years, Elena has developed a robust understanding of systems of deprivation of liberty and has become an expert in national and international legislation and jurisprudence concerning the administrative detention of migrants. Elena, the floor is yours. Thank you very much.
Thank you, Michael, and thank you for the invitation to this very interesting conference. I'm going to try to share my screen for to show you my presentation. No. No, era quella però, non potevo vedere. Scheda Chrome, vedi dove sta. Aspetta. Riaprilo un po', invece di metterlo in icona, questo tienilo aperto. Aperto. Ecco. Andiamo. No, devo mettere così. Okay. Good morning. Can you hear me?
Yes, you're coming through just fine.
Okay, great. In my presentation, I'm going to describe the state of play of the Italian administrative detention and its critical issues concerning the peculiar perspective of its normative deficiencies. This is a field where the law is often a step behind practices. I've chosen this key approach because it regards the whole system and discloses the deep roots of its persistent problems that, as we observed during our monitoring visits, cause a heavy impact on the migrants' human rights. Particularly intense is, therefore, the activity of the National Guarantor of submitting proposals and observations on existing and draft legislation on this matter. Acting as a national preventive mechanism under OPCAT, the consultation task pertains the role to find out structural problems and act to solve them definitely. I will start by explaining how in Italy from 2017, the immigration detention has been going through a phase of expansion. The boost showed differently. If we just focus on the arrangement of the places where migrant persons are deprived of their liberty, the expansion has manifested through, at first, as you can see, the enlargement of the network of the immigration removal centers. A law decree approved in 2017 planned to open new immigration removal centers in order to increase their total capacity from 400 places to 1,600 places. In these slides, you can see the locations of the centers and the steps of the implementation of the opening program. The process is slow but ongoing. From 4 centers operational in 2017, nowadays we have 10 centers located in different parts of Italy. As you can see in the table, the percentage of people repatriated from the centers is always quite low. That shows that the immigration detention in Italy also plays other roles, working as a deterrent for migration flows or as a surrogate of crime prevention policies or as an instrument of social exclusion to provisionally isolate those who are considered dangerous or undesirable. Another step of the expansion was taken in 2018 when a provision introduced new official places where administrative detention can be applied, namely cells within police stations and airports or ports to hold irregular migrants pending the forced return procedure on the whole, that is a good news, for no longer than 6 days. Since its approval, the National Guarantor highlighted the vagueness of this provision, which led to the police a very huge discretion in choosing and preparing these places, since it does not clarify any specific requirement these facilities should have. It only says in generic terms that they must be suitable. In the debate, if there will be the occasion, I might tell you something more about them. Furthermore, always in 2018, the law provided dedicated places within the hotspots and other first reception centers where asylum seekers could be restricted for no longer than 30 days for identification purposes. Until today, this restrictive measure has never been applied, and none of the hotspots or other first reception centers have arranged such dedicated detention facilities within their area. Finally, new forms of de facto deprivation of liberty affecting migrant people have been provided over the last years, such as the vessels used for search and rescue operations or for quarantine purposes. These are to be added to the previous informal holding practices similar to those put in place in the hotspots or in the waiting area at the airports.
Excuse me, I'm sorry to interrupt, but your slides are not changing. We're just seeing your first slide still. So I just wanted to let you know. Sorry for that.
Oh. Again?
Yep, we can see the next slide.
Vai sopra questa un attimo e fai di nuovo questa. Vedi un attimo se andando clicca sopra, se la possono vedere. Can you see that changing?
Mm-hmm. Can you see that changing?
Yes.
Yes, okay. So, okay. In the following two slides, there is the list of the current functioning facilities for holding migrants monitored by the National Guarantor. According to their legal framework, they can be divided in two groups. The official detention facilities, formally designated as places of detention, belong to the first group. As mentioned before, they are 10 centers, actually with a total real capacity of about 800 places. Then there are approximately 30 holding rooms at police stations. The second group includes places where a de facto deprivation of liberty is enforced. Are you able to see the slide regarding the de facto deprivation of liberty places?
No, we see the enlargement of the network of the immigration removal centers. That's the slide we're seeing right now. Sorry. There we go.
Now?
Yes.
Yes. Okay.
Vai avanti cliccando qua sopra.
Okay. Excuse me. The second group includes places where a de facto deprivation of liberty is enforced. Since the persons there hosted cannot leave those places at will until the authorities give them the permission, irrespective of the issuance of a formal detention order and their formal designation as detention places. It is the case of the closed hotspots at the border zone in the south of Italy, of the facilities used at the airports to hold foreign nationals who are refused entry until the carrier brings them back, but it's also the case of the floating places like the search and rescue vessels stuck at sea without the permission to disembark survivors and the quarantine ships. While mapping them, we have come across the Italian legislative flaws and their relevant effects, resulting indeed in situations of deprivation of liberty without the fundamental safeguards of habeas corpus. These hidden forms of detention will be the topic of the following panel, so I just mentioned them. All these places fall under the National Guarantor's mandate and compose a very busy map. Every facility is different from one another in terms of function, length of stay, material conditions, but they have something in common. They all lack the appropriate legal framework. That is crystal clear when we come across a de facto deprivation of liberty, but it's also true for the official administrative detention system. Therefore, its expansion without a consistent reform is of great concern for us. I'm going to focus on the normative deficiencies concerning the immigration removal centers in this second part of my presentation. Immigration, can you see the right slide now?
Normative flaws?
Great.
Yes, yes.
Immigration detention in Italy was introduced more than 20 years ago, but immigration removal centers are still lacking a clear and exhaustive legal discipline for the treatment of detainees. As already mentioned before, it's interesting to observe how also at international level, the Council of Europe is facing the same difficulties in codifying a coherent and clear set of international rules on administrative detention. The drafting process of the European rules of the administrative detention of migrants started several years ago, but it has never been completed. Compared with the Italian penitentiary law, the Italian legal framework on immigration detention is fragile. It does not offer an adequate and substantial protection. Despite the custodial nature of the measure, foreign nationals in the removal centers do not benefit from the same extent and degree of legal protection granted to persons detained in the penal system. It is as if the Italian law is not considering the restrictive nature of the detention order applied to them. The starting point of this idea is what the scholars call the semantic game of the Italian law. It avoids using the term detention in the Immigration Act and speaks of holding, that recalls the concept for a short stay. Even in the ministerial circular notes, it's impossible to find the word detainee. Obviously, as already said, a clear line of demarcation between administrative detention and criminal detention is to be drawn. We all know that the first one is not meant to be punitive, considering that it is not a sanction linked to a criminal charge. The problem is that the law often fails to provide the person held within immigration removal centers with the basic standard applicable to a person subjected to the coercive control of police. And in any case, it does not recognize the same standard of protection provided to prisoners. So legal provisions are not appropriate, and they leave a large degree of discretion in managing the centers to the public powers, which affects migrants' rights and favors the proliferation of arbitrary and informal practices. I'm going to give you some examples. Unlike prisons, the removal centers lack a comprehensive, specific law providing rules governing the treatment conditions and life within them. Even when, in very few cases, the law recognizes some rights to detainees, other national guidelines are somehow lacking or ambiguous. Let us have a look, for instance, to the right to communication. This is a very important right connected to the right of defense and the right to maintain family ties. The law expresses itself in broad terms of liberty of telephone communication within the removal centers. Well, we have been observing for years that this liberty is differently applied, depending on the decisions of the local authorities. Some allow migrants to use their personal mobile phones, others allow only those without camera, and finally, others, the most of them, withdraw all personal devices from detainees while letting the chance to use only public phones, thus with no possibility to receive calls. In the list of the removal centers' normative deficiencies, we should also include the use of force, which in fact has not a specific regulation. Moreover, police and other law enforcement agencies employed in the facility security do not receive any dedicated training for this sensitive task. Therefore, in case of riots, which are very frequent, state police has to face a situation they are not prepared for, and their approach is similar to that applied to managing public order during mass demonstrations. The fact that within the centers there are migrants without criminal charges and that among them there might be some vulnerable person or asylum seeker risks to be ignored. We should also consider that the external perimeter is always patrolled by the armed forces, which may intervene inside the facilities in case of necessities. At this point, would be useful to remember rule number 71 of the European Prison Rules, which remind us that prisons shall be the responsibility of public authorities separate from military, police, or criminal investigation services.
Elena, I'm sorry to interrupt, but I'm going to have to ask you to wrap up in a minute. Can you do that, please?
Yeah.
Sorry, we're just getting behind schedule. Thank you. Thank you.
Okay. Again, unlike the penitentiary law specific rule for healthcare staff employed in the removal centers aimed at identify any ill treatment are put in place. In general, the health assistant raises deep concerns since healthcare services, like any other assistance service to the person, are outsourced to private bodies, and the National Health Service plays a secondary role. That means the law does not even foresee its law-binding periodic oversight to check the quality of the assistance granted or the hygienic conditions of the premises. To understand the impact of such a deficiency, I will tell you about what happened 2 years ago. During a visit to the removal center in Caltanissetta in Sicily, the National Guarantor found out that the living conditions were so poor that they are a risk for the detainees' health. With the support of the physician, who was a member of the visit delegation, the monitoring body immediately sent a report to the territorial office of the National Health Service concerned, that some week later carried out an inspection to the center. The public body, which had never visited the facility before, arrived to the same conclusion of the National Guarantor. The environment was unhealthy and had to be fully renovated. The center was finally closed for refurbishment. In conclusion, a good news. Following the National Guarantor's request, the legislative body, a law decree approved last October, established that any migrant held in a facility can file a complaint with the National Guarantor on its detention conditions. If the complaint is considered grounded, the National Guarantor will make a recommendation to the authorities concerned to stop the violation. This is a very important law development, but it's a preventive remedy and does not guarantee that adequate redress can be obtained where necessary. A domestic compensatory remedy is still lacking, which will allow migrants in administrative detention to lodge complaints with a court and obtain adequate compensation in case of violation of their rights during the detention within the immigration removal centers. In fact, while the judicial authority verifies the lawfulness of detention order, its mandate does not cover the conditions in which such detention is enforced. We might say that the court stops at the gates of the facility, and except for the monitoring bodies, no other external and independent observer is allowed entrance. I could carry on talking about even other deficiencies, such as, for example, the lack of suicide prevention protocol. As Francesca said at the beginning of this panel, yesterday a young detainee committed suicide within an immigration removal center in Turin. This is another issue which should be treated properly, but we have no time. So on the National Guarantor website, it is possible to read our report on the visit to the facilities, our advices and annual reports to the Parliament, and our standards for the deprivation of liberty of migrants. Some of them are also available in English. I would like to finish my presentation leaving you the words of a foreign national included in a book on Italian immigration detention centers written several years ago, but still sadly present. Thank you, and I'm very sorry for the problems in sharing my screen.
Thank you, Elena, and sorry to rush you there. I probably should have reminded you or told you that, alerted you that the slides were not changing earlier. In any case, thank you for the update on Italy and for the information about the recent legal changes there about the complaint mechanism, which is obviously very important. I'm going to just quickly ask, we've got 3 more presenters, but we really want to have a Q&A. So to the extent that each of you can really stick to your 15 minutes or even less, I would be very appreciative. But obviously you have your time. So the next person that we have speaking is João Costa with the Portuguese NPM. João has been head of the Portuguese NPM since 2018. Previously, he worked with the ICRC, the UN's Office of Legal Affairs, and at the International Criminal Tribunal for the former Yugoslavia. He has extensive experience in the peace, development, humanitarian nexus, having consulted in Liberia and Cote d'Ivoire with the African Development Bank, in Afghanistan, Pakistan, South Sudan, Tunisia, with Search for Common Ground, in Ethiopia with the Dutch Relief Alliance. In addition to projects with Interpeace and with the government of Norway in various African and Middle Eastern countries, and with ICRC helping to develop an evaluation framework for its detention work across 90 countries. He's a PhD researcher at the University of Cambridge Institute for Criminology, and he holds an MPhil in criminological research from the University of Cambridge, an LLM from the University of Coimbra, with a focus and a BA at the University of Coimbra. João's presentation is the Portuguese Terminal detention centers in airports and their monitoring by the NPM. The floor is yours, João.
Thank you very much, Mike. I will also share my screen. Here we go. Do let me know, interrupt me, Mike, whenever, if there are any issues here. But good afternoon, everyone. Pleasure being here with colleagues from other NPMs, as well as international organizations and obviously academia. I do firmly believe that it is in this mix of perspectives that we enrich the discussions as we're all rowing in the same direction. I will be speaking from a practical perspective here as well. So I will reflect on the work of the NPMs in monitoring immigration detention centers with a focus in airports. And I'll start with a very brief overview about our NPM, especially after colleagues having explained what an NPM is, to be fair. And then I'll delve further into our work in monitoring airport immigration detention centers, especially focusing on main risk factors for torture and ill treatment that we've found across the years, how the situation has developed and how some of those evolve across time as well. The recent renovations of the Lisbon E-SIT, I'll explain what this means, but it's pretty much the airport immigration detention center of the Lisbon airport. And I'll try to leave some room. This is, I think, the most important part, something prospective. So what happens after the pandemic and where to go from here. So we work as the NPM within the Ombudsman's office. There's this idea of complementarity. The Ombudsman does receive the individual complaints, which the NPM does not deal with, but who have channels of communication. And most of my colleagues who collaborate with me at the NPM also deal with complaints for the Ombudsman. The NPM has a more forward-looking perspective, so we try to understand how can we avoid future complaints, in a sense, and look forward to improving them. We conduct those unannounced visits to places of detention, and over the recent years, we've focused on prisons, juvenile detention centers, psychiatric institutions, and immigration detention centers. We've also visited a couple police stations, but we do not have the necessary, funds and people, really. I'm the sole person who works 100% for the Portuguese NPM. All my other colleagues combine functions of NPM support and individual complaints within the Ombudsman's office. Even so, we've done some visits. 2019, we've done 45 visits. Visits tend to be relatively long, but 9 of them were to immigration detention centers, so 20%. So you see that we're probably half to prisons, 20% immigration detention centers, and the rest divided by other types of institutions. 2020, while the pandemic struck us, and for a while we suspended our visits, as a lot of our colleagues did as well, but we still managed to complete 34 visits, 6 of which to immigration detention centers, so keeping it proportional in terms of the attention we give to these situations. And the Lisbon Airport Migration Detention Center is actually the most visited place of detention in all Portugal by the NPM. I think we've been there, and my memory doesn't fail, but 7 or 8 times in the last 3 years. So you conduct individual reports after each visit that we send to the authorities responsible for the place of detention, and we provide annual reports that are discussed publicly in Parliament, and that's where we get a lot of traction from the media and from the politicians as well. I'm starting here saying that Portugal has one real immigration detention center in Porto, and that means because all the other ones are called, and this is what EECIT means, equivalent spaces to temporary detention centers for foreigners, and they're all located in international areas of airports. And those, again, this is one of the pictures. This is from after the renovation in the Lisbon one. And we've been visiting them very often, as I said, and signaling plenty of risk factors. start off with just the inadequate conditions of detention. I recall Hugh's presentation earlier today, where he was explaining like the carceral nature of a lot of these places, which are not designed for the purpose of immigration detention. And that was and is the case in most of the places situated in airports. And especially they're not designed for holding people for long periods of time. It should never go beyond 48 hours in our view, but in a way it has been up to 60 days. And I've called it a Kafkian solution because, and I'll explain this a bit further afterwards, but asylum seekers in Portugal used to be detained by default at the airports until very recently. And they would stay in the airport for up to 60 days. That's the maximum allowed per law. And then always released under a temporary visa. And this happened in 100% of the cases, really, because there was never a final judicial answer to their case. So they were pretty much detained for 60 days for no reason whatsoever, knowing very well that after those 2 months they would be entering the national terrain. And so a lot of the people who talk to us and say, yeah, I'll just stay here for 2 months, I'll deal with it, and then I'm in Portugal. So that was a bit of the weird situation that we've had here for a while. And while in Lisbon airport, there was often overcrowding with over 100 people where there shouldn't be more than 40. In Porto, we found often the other situation. So for times we've seen, especially women staying in a wing with no one else for weeks with nothing but a television playing Portuguese channels and not knowing why they were there, who they could talk to, anything. So situations which were quite dire, and we've signaled them plenty of times to the authorities. And as you can see, the main risk factors are all intertwined, because as I speak of one, the next one I've already mentioned. So there's nothing to pass the time really in these airport detention centers, no purposeful activities whatsoever, especially for lengthy periods of time. Then there's the problems of accessing personal items that were spoken before as well earlier by other NPM colleagues, insufficient medical care, especially psychological support, which was tout court absent, and even challenges to accessing a lawyer, especially before the renovations in the Lisbon Airport Center, where you needed to pay a fee, and that is true for the lawyer to get in the actual place of detention. So I guess these were the main risk factors signaled again over the years, which does not mean that there were not some improvements. Some existed. Some of our complaints or some of our reports had some echo and led to things such as improvements in food and shorter detention periods for minors, which a threshold of 7 days for us is obviously still way too long. We also keep on saying that detention is against the highest interests of the children, but unfortunately it hasn't fully materialized yet. But then there were 3 events last year that shocked the EC paradigm, so the immigration detention in airports. First, and obviously COVID, because the flux of migrants just diminished incredibly because there were airports closed, a lot of routes closed, so there's just no people coming in at our border. There were foreigners. Then we've had some incidents with Moroccan citizens in Porto and Faro, which led akin to riots, which damaged the installations and led to the temporary close and partially closing of Porto and Faro respectively. And I put a question mark after temporarily because it's been almost a year and it's still closed. No one knows what's going to happen to the place. And because there is not much need still for a place of detention in the Porto airport, things just continuing their life as if nothing has happened, which is also bizarre. And we would like it to get fixed, or at least to have some certainty regarding what's going to happen. Then finally, the most tragic one, which you might be familiar with, which was the death of Yor Umenyuk, an Ukrainian citizen in the Lisbon airport, allegedly, and there's a criminal procedure here, so by manslaughter by the border police, so actual aggravated assault that led to the death of the citizen. And this led to the temporary closure of the Lisbon Airport Center for renovations. And so the Lisbon EEC did suffer profound renovations, mostly because after this tragic event of the death of Yor, there was a huge public backlash because the situation, despite the NPM's efforts of raising publicity about the prior inadequate and inhumane conditions of the place, nothing actually changed in terms of substance of the deeper things or structural things that needed to change. And the public was not fully aware of the conditions. And there was a big shock that in 21st century Portugal, an immigrant could be killed at the hands of the police. But most of the changes of the renovations that has happened in the Lisbon EC, it pretty much followed the script or a roadmap of the NPM's reports, although most of the suggestions that they followed before they used to deem unrealistic, inadequate, borderline ridiculous, and they were met with a lot of criticism and defensive stances. But some of these changes that did happen, and for the best, was that the space itself became less carceral. So there's a few colors, even if not many, as you can see in the picture, but the walls are painted and the conditions slightly improved. Asylum seekers stopped being detained by default, which is also great. Now they're handled through a refugee service in Portugal who provides for shelter, etc. People in general are detained for shorter periods of time as a consequence, because in the ASC, they only stay those who are then re-embarked to their country of origin. So 7 days has been the upper threshold, but we've noticed that there's been 48 hours, 72 hours normally. Then lawyers and personal visits have less barriers to entering the place of detention. So finally, they're able to access the place of detention without having to be accredited by the airport institutions. There's no dormitory style accommodation, but now individual bedrooms with a card so that persons can go in and out and retain their privacy as they want. They finally got access to mobile phones, although Wi-Fi we were told that they would have Wi-Fi. In our latest visit, we realized that it wasn't the case. A family bedroom was created with toys for kids. Well, we prefer the kids not to stay there, but if they're there, at least let them have a room with their family and with some toys. Now they can wash and dry their clothes there in a machine rather than just hanging them at the small patio, which was a very bizarre, fantastic view, really, with bottles of water that used to hold the clothes as they would dry before this. And some entertainment was provided, some books, board games, and an expected stationary bicycle. And here, and this is actually my concluding one, so Mike, I hope I'm being good. But I want to reflect here. I want to kind of saving, I hope, the best for last here, because there are multiple issues that are still an unfortunate reality. So first, there's not enough harmonization of rules between airport detention centers in Portugal. And there's two areas here that flag, that are quite, where the red flags come up. One is in terms of mobile phone usage, because now it started in Lisbon, but it's not certain what will happen in the other ones. And the second is procedures for asylum seekers, because if you remember, I said that now in Lisbon, after the renovations, asylum seekers are not detained by default and are actually granted a temporary visa to enter Portugal. However, in visits last year, after these changes in Lisbon, some of these airports, such as Faros, were still detaining asylum seekers. So this discrepancy makes no sense in a lot of ways, both normative and in terms of even common sense. Then again, these places in airports should never hold citizens for more than 48 hours. So there's still now the cases where they go over 48 hours, they mostly due to the pandemic because of the lack of flights, but still we should continue making efforts to avoid long periods of stay in a place that is not designed for the purposes of detaining for longer periods of time. And finally, and this is where I would love to hear your input as well, because there is an urgent need of alternatives to immigration detention centers in the airports. Because as I said, we only have one of such centers in Porto. And now would have been the time to change this, to profoundly change the system. Because now we needed, so Porto is in the north of Portugal, Lisbon is sort of center, and then we have Algarve, which is in the south. Both the Algarve and Lisbon are huge hubs for migrants, for the entering of migrants in the country. And there's just no alternatives to the immigration detention centers in airports. So the question is, now the flow of migrants is low, right? But the flights will return to pre-pandemic times. And when they do, where will the people go? especially because the Lisbon Center now has individual bedrooms and not dormitory style. So you're not even supposed to have as many people as you had before. There's literally no space. And then not just that, but if you're not detaining asylum seekers, where will they be in general? Will they have enough accompaniment? We obviously don't want them to be detained, but we want them to have appropriate conditions in order to, wait for the final decision regarding their request in a humane situation. Then Porto is still closed. And why hasn't it been renovated following Lisbon's example? It's been a year. So we've been constantly pressing on this matter and we still get no answers. And finally, related to the first point that I started off with, there have been some projects for immigration detention centers in Lisbon and the Algarve, but these have repeatedly failed. So since I've been at NPM since 2018, it's always in the next semester that one will open, always. And for various reasons, it has never happened. And I think now when we have the time, the chance, and after such a tragic event, which led to the political will even to change things, this should have been the time to employ such changes and ensure that humane detention existed. So yeah, thank you for listening. That's it for me.
Thank you very much, João, for that presentation. Just before we move on, the organizers have granted our panel 15 more minutes. Thank you very much. I think we're going to need that time for the Q&A. Before we go to the next speaker, I wanted to just quickly follow up with you, João. It's not for you to answer now, but I think it's a point that I'd like to just put on the table for the Q&A when we get there. The issue of this idea that things are inappropriate for detaining people, we need to find alternative places to put them. I just wonder if this is something that we would come back to in all the NPM's experiences, all the experiences of CPT monitoring as well. Is the objective to find places, or is the objective to not detain? I just think that that's kind of at the threshold here. When we look at the role of human rights monitoring, I think it may come up in some of the final two speakers. Thank you again, João, for that presentation. Our next speaker is Carmen Comas-Mata. Carmen is a lawyer specializing in human rights, a Spanish lawyer specializing in human rights who has worked since 2000 at the Spanish Ombudsman's office and since 2019 as a member of the UN Subcommittee for the Prevention of Torture, where she was recently elected as vice chair. Carmen was the first director of the Spanish NPM and has participated in more than 400 visits to places of detention in Spain. In 2011, she was appointed by the Spanish Agency of International Cooperation and Development to work with Peru in its ratification of the optional protocol to the Convention Against Torture. Carmen's experience also includes working on various projects for the Council of Europe concerning the strengthening of national human rights structures and European NPMs, working as a field worker, visiting Spanish prisoners abroad, as well as visiting places of detention in Latin America, Asia, Africa, in addition to Europe, serving on the monitoring team for Frontex repatriation flights organized by Spain, and working at the General Secretariat of the Latin American Ombudsman Federation, which brings together more than 100 ombudsman's offices in the region. Carmen, the floor is yours.
Thanks very much. Thanks very much as well to the organizers for inviting me and for inviting the SPT to this conference. I'm going also try to share my presentation, but please do interrupt me if you cannot see, sorry, here and then here. Whoops. Sorry. I don't know whether you can see the presentation. Can you see it? Yes?
Yes, we can see it. Yes.
Okay, it's because I have a system of 2 screens and sometimes it's a bit difficult. So, well, let's start. Every year, and according to Global Detention Project, more than 100,000 people are put in immigration detention in Europe. In immigration detention, people are uprooted from their communities, and they often don't know whether and when they will be released or deported. Often, people in immigration detention don't have access to adequate information and interpreters, legal aid, and medical care, as we have already seen in the previous presentations. Immigration detention is not a new phenomenon, but there are no precedents in recent history of its current massive use by states to control borders and manage migration. Whether as an administrative practice or as a consequence of the criminalization of migration, detention of migrants affects an increasing number of vulnerable migrants for increasingly long periods of time, often in conditions which fall far below the standards set by international human rights law. In this context, the latest proposals of the EU Commission in the framework of the Asylum and Migration Pact expects a greater incidence of detentions, both due to the increase in the reasons and periods of detention, as well as limitations on rights. The detention of refugees, migrants, and stateless persons has become a frequent and frequently arbitrary and disproportionate response to violations of immigration law. Detention is most commonly used where migrants enter a state illegally or overstay their leave. Although asylum seekers, children, victims of trafficking, and stateless persons are recognized as vulnerable groups under international law and entitled to special protection, many are detained in some countries. Over the past few months, immigration detention practices around the world have been changing rapidly as state and civil society actors respond to manage the multiple impacts of COVID-19. In some cases, these changes have been positive, leading to a stronger protection of the rights of non-citizens. In others, they have led to increased marginalizations of and discrimination against non-citizens. The closure of borders, restrictions on international and local travel, changes in status determination procedures for asylum seekers and refugees, new regulations concerning visitors and lawyers in detention facilities, the redistribution of detainees across different facilities, the introduction of quarantine and isolation procedures for those with COVID-19 symptoms, and the impacts of immigration detention practice on the mental health needs of detainees are features of the current situation that need to be taken very seriously. That is why the scrutiny of international organizations in charge of monitoring human rights, and more specifically detention conditions, is so important. States reluctant to accept the constraints on national policies set by international human rights law has been particularly acute in the case of irregular migrants. Why is this? In Adela Cortina's words, which is a Spanish philosopher, what lies deeply within this is a feeling of aversion, of rejection of the poor, aporophobia. What bothers, first of the immigrants and then of the refugees, is not that they are foreigners, but that they are poor. All phobias, homophobia, Islamophobia, xenophobia, are social pathologies that are expressed in the form of hatred of the different, but this one comes masked. Some national legal systems have adopted narrow and restrictive interpretations of international human rights when detention is challenged by non-nationals. And unfortunately, the European Court of Human Rights has sometimes endorsed these practices from the states. The most notorious case is the judgment ND and NT versus Spain of 13 February 2020, where the Grand Chamber held that Spain's summary expulsion of 2 migrants from Africa did not violate the European Convention of Human Rights. They were a part of a large group that scaled the Melilla border fence between Morocco and Spanish territory. It was the first time that the court considered that the applicants were not entitled to protection from mass expulsion because of how they entered Spain. The reason was that the applicants could have sought asylum at a consulate or border crossing, despite evidence that Moroccan authorities prevented sub-Saharan migrants from reaching those places, and that Spanish authorities did not actually have the relevant procedures in place at the time. This being the case, non-judicial and international oversight plays an essential role in protection. As the use of immigration detention has grown, so has awareness of the challenges it presents to human rights, both within the European sphere and the United Nations. Assessing the measures states take with regard to the detention of migrants should include a review of applicable national laws to ensure that they are harmonized with international human rights norms that prohibit inhuman and degrading treatment and ensure due process. This review should include an investigation of measures to ensure that detention of irregular migrants is not arbitrary and that there is a national legal framework to govern detention procedures or conditions. For example, regarding the separation of migrants from criminals, as well as an assessment on administrative versus criminal detention procedures. Actors may assist states in developing and implementing system of alternatives to detention of undocumented migrants, which should provide strong procedural safeguards, including the obligation to have a judge decide on the legality of detention and on the continuing existence of reasons for detention. I will not dwell on the European sphere because, as we have seen in the former interventions, the CPT has shown in Europe its important role in monitoring national detention practice and conditions, complemented by human rights and migrant rights NGOs. Same can be said of the Inter-American Commission of Human Rights in the sphere of the Americas, which has produced a number of important reports in the matter. As regards the United Nations, the Human Rights Council has taken an important role in this issue. First step was taken by the Human Rights Committee in 1997, when the mandate of the Working Group on Arbitrary Detention was extended to cover asylum seekers and migrants. The Special Procedures Mechanism offers a range of advocacy tools to promote the human rights of migrants. Mandate holders may work with a wide spectrum of factors in carrying out their mandates, including governments, national human rights institutions, United Nations officials, the media, civil society representative, etc., etc. The most important is the Special Rapporteur of the Human Rights of Migrants, whose main task is to examine ways and means to overcome the obstacles existing to the full and effective protection of the human rights of migrants, including obstacles and difficulties for the return of migrants who are undocumented or in an irregular situation. The United Nations human treaty bodies include non-nationals in the review of states' treaty compliance, and state detention practice are considered in the Universal Periodic Review. An international development of particular significance was the establishment of the monitoring body under the Convention Against Torture. The optional protocol to the Convention Against Torture, the OPCAT, entered into force in June 2006, creating a subcommittee on prevention of torture, the SPT, which I am representing here today. It has a mandate to visit places of detention, including, of course, places of immigration detention. Under the OPCAT, the SPT has unrestricted access to all places of detention, can make unannounced visits to police stations, prisons, detention centers, including immigration ones, of course, and other places where people are deprived of their liberty and meet in private with detainees. Through its practice, the SPT has set a sort of doctrine that can be summarized as follows. First, immigration detention should only be applied as a measure of last resort after it has been determined on a case-by-case basis to be strictly necessary, proportionate, lawful, and non-arbitrary, imposed for the shortest period of time and for a legitimate purpose. Second, when it's strictly necessary to do so, such migrants should not be detained in a prison-like environment, but in facilities equipped to provide adequate recreational, physical, and cultural opportunities to which the migrants have effective access. Issues like heating, cleaning, and decent conditions of the centers must be always considered. Third, the state's party should promptly provide undocumented migrants in detention with detailed and accurate information and in a language they understand concerning their legal status and all the procedures affecting them, including their refugee status determination, deportation, and possible means of appeal and remedies. Effective means of providing such information should be available in respect of all such detainees, including those who do not have their own lawyers. Fourth, states parties should take the steps necessary to be able to detect acts of torture and ill treatment in migrant holding centers, and that it thoroughly investigates such acts and impose administrative and criminal sanctions on the perpetrators. It also recommends that the states party provide adequate assistance and protection to migrants who report acts of torture and ill treatment. Fifth, migrants in detention must also be provided with access to medical assistance at all times. Also, clear protocols for the prescription of medication in the detention center should be established. Such protocols should refer to international pharmacological standards, and informed consent should be obtained from the undocumented migrants for any such treatment. States party should take the necessary measures to protect the physical and psychological integrity of lesbian, gay, bisexual, transgender, and intersex persons at detention and also at temporary migrant reception centers by shielding them from ill treatment. States party have to provide unaccompanied minors with a guardian to keep them informed of their legal situation and to effectively protect their interests. The state party should also equip the facilities with adequate means for the minors to communicate with the outside world, their families, and their legal counsel. Besides, every unaccompanied minor has to have effective access to an education that is suited to his or her needs and abilities, and that is designed to prepare him or her for inclusion in society and have sufficient opportunities to participate in sports, in arts, etc., etc., etc. Are there international and European custodial standards? One practical difficulty is that international custodial standards, notably the United Nations Standard Minimum Rules for the Treatment of Prisoners, apply specifically to prisons, but the immigration detainees are held in many other places. In the context of Europe, the CPT has not the lack of a comprehensive instrument setting out the minimum standards and safeguards for irregular migrants deprived of their liberty, which are in line with the specific needs of this particular group. Although the European prison rules apply to immigration detainees held in prisons, they do not apply to immigration detention centers, police stations, and other places of immigration detention. That is why within the Council of Europe framework, a draft instrument to codify existing international standards relating to the rules of the conditions and detention of migrants is being prepared. But the pandemic has stopped everything, and I hope that the works will be resumed as soon as possible. The Frauenheit site has published several interesting reports concerning reception facilities as external borders and has selected European legal sources for dignified reception conditions as shown in this slide. Several bodies of the Council of Europe, the United Nations, and the European Union have highlighted that immigration detention must always be an exceptional measure of last resort. This entails that detention can only be justified if, after a thorough and individual assessment of the particular circumstances in each case, it has been established that less coercive measures are insufficient. A number of instances have similarly emphasized the obligation of states to examine alternatives to detention as a general principle before any decisions to deprivation of liberty is made. A legitimate purpose for the detention of refugees, asylum seekers, and migrants is equal to a legitimate purpose for the detention of any other persons. That is, when someone presents a flight risk from future judicial or administrative processes, or when someone presents a danger to their own safety or for public safety. In all cases, immigration detention should only be used as a last resort after having explored alternatives to detention for each individual case. Around the world today, we are witnessing several impacts of the use of migration-related detention of migrants, asylum seekers, and refugees during the COVID-19 pandemics. I am referring to indefinite detention in overcrowded facilities for some, prolonged situations of irregularity and fear of detention for others, heightened risk of infections for all, migrants, staff, their families, and their communities. A few weeks ago, the United Nations Network on Migration released a document containing practical recommendations with guidance for states and stakeholders on preventing and responding to COVID-19 in the context of immigration detention. By focusing on the development of non-custodial alternatives based in the community, the brief highlights steps that several governments have already taken to swiftly release migrants from detention and to provide access to healthcare, housing, and other services regardless of migration status. The network calls on states to introduce a moratorium on the use of immigration detention, to scale up and implement non-custodial community-based alternatives, to release all migrants in detention into alternatives, following strict safeguards and prioritizing children, families, and other migrants in vulnerable situations, and to urgently improve overall conditions in places of immigration detention while transition to alternatives is implemented. The COVID-19 has created a momentum for alternatives to immigration detention, and I hope that states will make the most of this momentum, in my opinion. I would not want to end this intervention without trying to imagine a little bit the future. As reflected in the latest proposals of the EU Commission in the framework of the Asylum and Migration Pact, a greater incidence of migration detention can be expected, both due to the increase in the reasons and period of detention, as well as limitations of rights. The new design of the return system includes the reform of the return regulation, but the most important introduction is the proposal for the screening regulation. Basically, a mandatory pre-screening is established at the border to check ID and security threats, register biometrics, and verify health and vulnerabilities for identification, and then referral to asylum or to return procedures. The screening would last between 5 and 10 days. Although the regulation is silent on detention, it is difficult to imagine how screening every third country national without authorized entry could be implemented without it. In practice, member states use formal or de facto detention for almost all applicants when a border procedure is applied. There is a strong risk that member states will call this reception or accommodation, leading to the worst case scenario from a fundamental rights perspective. De facto detention with detainees deprived of the safeguards that apply in formal detention regimes. Another problem is that it is accompanied by a non-entry fiction, so it is presumed that people have not entered EU territory until they have completed the screening. Here, the alarms have soared as to whether this fiction also intends not to apply to the EU legislation and international standards on detention or return during screening. If the person applies for asylum, he or she should not be detained on grounds other than those under Article 8.3 of the Reception Conditions Directive. Again, detention should always be a measure of last resort and formally defined as such so that safeguards apply. The same screening procedures will also apply to people already in the EU territory, independently of how long they have been living in Europe, if there is no indication that they have entered regularly. In this case, people can be detained in specialized facilities for up to 3 days. The good news is that the regulation provides for a specific independent monitoring system to be established at the national level applicable to the procedure and conditions of detention. To ensure that this mechanism is effective, it needs to be expanded beyond the screening procedure, to be independent of national authorities and to involve independent organizations such as NPMs, Ombudsmen, and/or national human rights institutions. Allegations of violation needs to be investigated with disciplinary measures and individual remedies to follow as relevant. There should also be oversight, including by parliamentary bodies, and an obligation to prepare periodic public reports on findings and outcomes of monitoring. hopefully, international bodies as CPT or SPT will have an important role in monitoring detention conditions of migrants until the day will come when states are convinced that other ways of controlling migrations are possible. Thank you very much.
Thank you very much for that presentation, Carmen. You've covered a lot of ground. I'll quickly go to our final panelist today for this panel, which is Hinpal Singh Bui. Hinpal is the inspection team leader at the UK's Inspector of Prisons, or HMIP. He leads inspections of prisons and other forms of custody in England and Wales and heads inspection of the immigration detention estate in the UK. He led the HMIP team that developed new monitoring methodologies during the COVID-19 pandemic. He is also a visiting professor at the Center for Criminology at the University of Oxford and has published widely on prisons, probation, race, criminal justice, foreign prisoners, and immigration detention. He has advised and trained custodial staff and monitors in various countries in Europe, the Middle East, Far East, and Africa. In recent years, with colleagues at Oxford, he has undertaken research on human rights-based detention monitoring in several countries at Europe's borders. Hinpal, the floor is yours.
Thanks, Mike. Can you hear me? Yeah. Okay. So my just to say, my connection has been coming in and out. So if someone can give me a signal, if it looks like I've disappeared, then I'll reconnect. I should say I don't normally dress this way just for a conference talk. I'm not sitting in my back bedroom. I'm currently in a prison. That's why I've had to dress up. So I hope that doesn't disturb anyone. So colleagues have spoken in some detail, I think, about the general principles of independent inspection and about how monitoring works. So I'm not going to go into that. I'm going to bring this down to quite a small scale, really, and talk about the challenges of inspecting immigration detention and to some extent prisons too, because you know, the approach that we developed to looking at prisons informed immigration detention monitoring here. So I'm going to talk about that in a bit more detail. Suffice to say that HMI Prisons is like other NPMs in that we carry prison keys, we can access detention areas at all times, we inspect prisons, police, detention, and also inspect the immigration detention estate, which comprises of around 7 large immigration detention facilities. And there are about 80 smaller ones. We thought there were fewer, but many more have recently emerged. And we also look at removal flights. So we inspect charters and individual removals. So like most NPMs, in March 2020, we suspended our normal inspection program, and that was for very clear safety reasons. But more or less straight away, we decided that we needed to start to explore how we could safely resume our inspection program to meet our legal duty to provide independent monitoring and, of course, adhere to our international obligations under.
Ooh. Hi, Hinpal, we've lost you. Don't know if you can hear me or not. Maybe one of the organizers has Hinpal on WhatsApp or something.
Yeah, I'm gonna message him.
Hi.
You're back.
I'm back. Thank you. I'm so sorry about that. I'm afraid that might happen again. I'm not sure where you lost me. Can someone tell me?
I think it's because you're in a prison, aren't you?
Yes, that's right.
Maybe there's some kind of.
I'm not sure where you.
Monitoring in COVID.
Thank you. Right. So. Okay. So, like.
Hinpal, sorry. Do you wanna turn your video off?
Yeah, I'll do that. Maybe that'll help.
Maybe that you have a bandwidth issue. Yeah.
Right. Okay. Like most NPMs, in March 2020, we suspended our normal inspection program for safety reasons. And more or less straight away, we began to explore how we could safely resume our inspection program. And that was to meet the legal duty to provide independent monitoring and to obviously adhere to our obligations under OPCAT. So in April 2020, we implemented what we called a short scrutiny visit methodology. And that was in both prisons and immigration removal centres. And it was accompanied by a new and very extensive health and safety policy. And that included, for example, changing clothes on entering and leaving detention. We didn't use public transport, and more recently, we've required all of our staff to be tested for COVID every week routinely, and then again on the day they enter the detention environment. So we wanted to return to inspection quickly because, of course, we know of the particular concerns that can arise in detention, but also because of the reports and the rumours that were starting to emerge about what was going on in detention and in prisons. So the concerns included, for example, very long lockup in shared cells, COVID running rampant, the risks of sharing confined spaces, physical and mental health problems, staff shortages. As more staff became ill, of course, that reduces the number of people who are available to look after detainees. Challenges of providing suitable accommodation for detainees released into the community. For example, if they needed to self-isolate, we knew that would be a problem. And finally, I suppose the underpinning concern was that, as with all places of detention, without some kind of external scrutiny, we thought they might start developing their own unique standards, leading to worse treatment of detainees. So these visits, these short scrutiny visits, were started in April 2020, and initially they were undertaken just by 2 to 3 inspectors, always including a health inspector, and for 1 day only. That compares to our full inspections, which we've just restarted, which entail about 12 people for around 2 weeks. So we sent different teams to these sites when we did these short visits, to 3 or 4 sites on the same day. We looked at a small number of key issues of most importance to basic rights. We did a lot of interviews, both by phone and face-to-face, and by early July 2020, when this methodology was replaced by a different one, we had visited 31 prisons and 4 immigration removal centres. So one of the most surprising things about this programme was how enthusiastic the government, the prison service and the Home Office were about it. And that, I think, was because prison and detention directors were in really uncharted territory. They were taking what would in normal times be seen as exceptionally restrictive, punitive actions to control the virus. And they felt they needed an independent perspective on their decision-making. So on the whole, we found that the initial response to the crisis in prisons had been quick, quite proportionate, well communicated to prisoners and detainees, and it had been generally effective in controlling the virus. Surprisingly, despite being locked up for very long periods, most people we spoke to in prisons and detention were understanding about the reasons for the action taken. But the more hidden costs of the restrictions didn't take too long to come out. So, for example, again, talking about prisoners, time out of cell, work and education were severely restricted, and the suspension of visits and loss of face-to-face contact with children and families were obviously very painful. We decided to explore some of this impact by completing a thematic report based on interviews with 72 prisoners in 6 prisons between September and November 2020. So the idea was to increase understanding of experiences of prison life during the pandemic and to make sure that the restrictions were not seen as being in any way acceptable in the longer term. We found a lot of anxiety among unconvicted prisoners who had spent longer than a year in prison waiting for their trials. There was a decline, an understandable decline in emotional, physical well-being and psychological well-being. There's chronic boredom and exhaustion, as most people were spending at this stage about 23 hours locked in their cells. Prisoners described using unhealthy coping strategies, including self-harm and drugs. They were given very limited support as they came up to release. And the picture was generally bad, despite the fact that there was some positive learning as well. And that included, for example, the use of video calling, which had never been used in prisons before, but has now become quite established and helps people to keep in touch with their families and friends. So by the summer of 2020, we'd ourselves decided that it was safe enough to increase our scrutiny, to start doing 3-day visits. And that included a survey of detainees and 5 or 6 inspectors. So while the earlier visits were designed to provide transparency in relation to a system navigating its way through the COVID-19 crisis, these new and longer visits were designed to examine the speed of recovery and response to changing circumstances. So since July, we've undertaken 37 prison visits, 1 immigration removal centre visit, and a number of other immigration visits. We were due to visit 2 more immigration centres, but these were cancelled because we decided that virus outbreaks, just as we were due to visit, made it too risky to go in at that time. So moving on to immigration findings specifically. So it soon became apparent to us that the immigration removal centres were not as big a concern as the other types of immigration detention. We found a big drop in detainee numbers, understandably, because if there's no prospect of removal, detention ceases to be legal. So numbers were very low. Detainees were usually held in single rooms, usually with their own toilets and showers. That helped stop the spread of the virus. And we saw none of the extreme restrictions that we saw in the more crowded prisons. Detainees generally had good freedom of movement. They had access to activity, and most could work if they wanted to. The number of staff remained the same despite the drop in the number of detainees. And that meant that care was usually at quite good levels, and levels of self-harm and other levels of distress were generally lower than we've often seen. That's not to say that there wasn't a very high level of vulnerability. We saw that about 40% of detainees in the centres we went to had been assessed as being vulnerable under the Home Office's own system of assessment. And many were still being held for very long periods without, as far as we could see any obvious prospect of removal in the short term. The suspension of social visits was also very difficult for some, of course, although detainees had been given free telephone credit and access to video calling. But so this wasn't, the immigration removal centres, though, despite these concerns, weren't the biggest concern of ours. Our big concern was about migrants arriving usually across the English Channel in small boats and then being held in more ad hoc detention facilities. That's where the value of ongoing scrutiny became very clear to us very quickly. So we visited 5 sites in September 2020, which are used to hold migrants who've just made, often migrants who've just made these dangerous crossings across the Channel. After rescue, most people were first taken to a place called Tughaven. This place looked like a building site. It wasn't fit for purpose. Migrants were arriving wet and cold and then usually spent hours in the open air or in cramped containers before being transferred. Basic supplies of clean and dry clothing were regularly running out at most of these sites. And we saw very crowded conditions. And people were being held for very long periods without access to sleeping facilities, to showers, or even to the open air. For example, a 15-year-old unaccompanied child we found was held for 66 hours in these conditions. Safeguarding was very poor. In one case, a child had been mistakenly transferred to an adult detention centre, and in another, a child had been transferred to asylum accommodation without social services being informed. And we found a general failure by the Home Office to prepare adequately for what we considered to be predictable increases in migrants arriving in small boats. So this wasn't actually the worst of it. In February 2021, there have been many reports of poor treatment of asylum seekers held in military barracks accommodation. And in February, we visited 2 sites with the Immigration and Borders Inspectorate. So this was a little difficult for us politically because these places were not defined as detention. However, they were large-scale sites with lots of migrants, and we were used to inspecting such facilities. So we struck an agreement with the Immigration and Borders Inspectorate, who had the right to visit these places but had little experience in looking at this type of accommodation. And we went in together. So here we thought the treatment was extremely poor. Managers at both sites lacked the experience and skills to run large-scale communal accommodation. In many respects, they didn't seem to know what they were doing. The government's own health advisors had told the Home Office that opening multi-occupancy dormitory-style accommodation during a pandemic was not advisable. No surprise there. But these sites were opened with minimal preparation before health recommendations had been implemented. So not surprisingly, perhaps, there was a major outbreak of COVID at one camp where over 100 people tested positive. This, to us, appeared to be inevitable. And again, we concluded there had been a fundamental failure of planning and leadership by the Home Office. There were high levels of mental health concern, safeguarding failures, inadequate support for people who'd self-harmed. People who were at high risk of self-harm were placed in a decrepit building, which is unfit, in my view, for human habitation, and in a worse state than nearly all of the prison and segregation isolation units that I've seen. It also housed people who said they were children, in some cases for up to 2 weeks. In short, these conditions were really pretty disgraceful, and it was really essential, I think, that we went there. So what was the impact of these visits, and did the calculated risk of visiting so many sites during a pandemic pay off? A few concluding points to help answer those questions. Well, first of all, we always think that informing the public and politicians about what is being done is important in itself, and this did lead to some fairly quick action. After we reported our findings, one of the asylum camps was closed almost immediately. The isolation unit at the other one was also closed immediately, and the numbers there were reduced. We've also been shown extensive improvements made at the first facility I talked about at Dover. Going back to what's happening in prisons, after all the visits we did, there's far more activity available. Face-to-face work with resettlement and release professionals has restarted. And although it's been a challenge to balance the risks of virus transmission with our commitment to inspecting detention, we think that by following our very strict health and safety protocols, we've just about pulled off that balancing act. We don't think that we have taken the virus into any establishment, nor do we think any of our staff have caught it and brought it out. We also think that some of the pandemic-inspired innovations, which we think should last into the future, like, for example, video calling technology as a way of staying in touch with friends and family, I think they're going to be reinforced by the fact that we've gone in and shown how effective they can be. I suppose finally, I should just say we were quite nervous about our approach, understandably. It was quite intrusive, it was quite pushy. The prison service and the Home Office detention facilities were all very concerned about what we were doing. But I think our pushy approach was probably justified, particularly by the quite shambolic ad hoc detention that we found. And we were concerned that this kind of thing, without our involvement, might almost become a kind of a new normal, without it being exposed and without the shortcomings in this sort of approach being publicized widely. And as I said, we have just this week, actually, last week and this week, returned to fully inspecting. Okay, I'll stop there. Thank you.
Thank you very much, Hen.